And good afternoon. Welcome to today's edition of Ask a Lawyer on Facebook Live. I'm attorney Michael Bender.
And I'm attorney Allison Tilton. And we are
the Great Legal Group. Those who have been following us on a weekly basis, you'll understand why we're laughing here. The information in this, the content of this video is for general information purposes only. Nothing should be taken as legal advice for any individual case or situation. This information does not intend to create, in receipt of viewing, it does not constitute an attorney-client relationship. Jump right in here to our first question of the day. Allison, you get to go ahead and do this one. What is the difference between a divorce and legal separation? My husband and I recently separated and started living apart. I'd like to file for a divorce, but I'm not sure I am ready. Will a legal separation affect a future divorce proceeding?
Okay, so essentially there are two filings. So there's actually three filings that you can do in family court, but we're going to focus on the two. You can file for a divorce, you can file for a legal separation. Those two filings are essentially the same thing. If you file for either one of them, the court will have the ability to make orders regarding custody visitation if you've got minor children, child support if you've got minor children, spousal support if it's applicable, property division, and attorney's fees if those are also applicable to your case. The main difference between the two is that in a divorce, the court will terminate your marital status. So when you enter your judgment of dissolution, you essentially become a single person, separate and apart from the other person. If you enter a judgment of legal separation, the two of you, the husband and wife, remain married. You still have all the perks of being a married person. You can file filing joint tax returns. You can maintain health insurance. You basically get all those marital benefits. If down the line you decide that, hey, we don't want to be married anymore, we want to be single, for whatever reason that is, there is the ability to either convert your legal separation to a divorce or, if necessary, file a divorce action and then just terminate marital status. So it doesn't affect your ability to later seek a termination of marital status.
I think the quickest way to summarize the difference between a divorce and a legal separation, we say it all the time, a legal separation is basically a divorce without the divorce, because you do remain married, but you've taken care of all the rest of the issues in the case.
Absolutely. All right, let me go ahead and ask Michael this next question that came in. How long after a divorce can you go back and get alimony? My ex and I divorced in 2010. I never asked for alimony, but since then I've suffered financially. Can I go back and get retroactive alimony from him?
Well, the perfect lawyer answer here, it depends. First off, as far as retroactive alimony, well, first let me back up here. Alimony really doesn't exist in the state of California. It's actually called spousal support. As far as retroactive, probably not. If there was no orders for spousal support made at the time of the divorce or at any time during the pending divorce, you're not going to be able to go back and ask for spousal support then. Being able to ask for spousal support from now into the future, basically a post-judgment modification of spousal support, it really depends upon how the judgment reads. Back in 2010, 6 years ago, circumstances were such that you didn't either ask for it, you were self-supporting at the time, or nothing's changed, however, you reserved on the issue of spousal support. If there's a reservation of jurisdiction, you'd have the ability to go ask for it. The problem that this person's going to have is it's been 6 years. A lot has happened since then, and the court may ask, why are you not self-supporting, self-sufficient at this point in time? Because that's one of the major factors that the court looks at when awarding spousal support.
I think the only thing that you left out of that answer was depending on the terms of your judgment, it is possible that the parties terminated the court's ability to award spousal support quite frequently when parties do self-represented judgments or they go to the family law facilitator's office. It's frankly, it's a check-the-box form that parties use, and more often than not, you've waived or terminated spousal support.
You definitely have to look at that judgment very closely when you're looking at the financial aspects of it, because if that checkbox is there for terminate, it's done. Nothing that can be done about it at all in the future. Special bonus question for our Ask a Lawyer today. Can I get my divorce expedited? My wife and I want to file for divorce, and it's uncontested. No children, no spousal support. I want to get married to my fiance in November. Because we are in agreement, am I able to expedite my divorce case?
No. We tried to time that for you.
Did our best.
So, no, there's no expediting of divorce cases in California. You sometimes hear people say, I've got to wait 6 months. What that is there's essentially a 6 month and 1 day rule. And that's the date that you've served your spouse, your soon-to-be ex-spouse, with the petition. So the petitioner files a petition with the court. They get that back from the court. The respondent or other spouse has to be personally served. There's a 6 month and 1 day clock that starts running from that date of service, but it doesn't mean that you're going to be divorced in 6 months and 1 day. So if you're essentially trying to expedite the divorce case, once your case has been filed and the spouse has been served, you can either enter a judgment and then the court will enter a marital termination date 6 months and 1 day from the date of service. Or alternatively, if the case is dragging on, even though you think it's going to be uncontested and even though you think that everything's going to be great, more often than not it doesn't work out that way, you can go in and you can ask the court to bifurcate. And what that means is the bifurcation is a request to do an early termination of marital status while the rest of the divorce case is filing. And by early termination, still 6 months and 1 day, no way to get it any sooner than that.
If everything's going smoothly and you go ahead and figure out that date of service, you can start that countdown clock. Earliest it can be done, 6 months and 1 day. That's as fast as it can be. I want to thank you for joining us on Ask a Lawyer. Join us each week as we discuss family law issues important to our community. If you have a legal question or topic you'd like us to discuss, go to thegreatlegalgroup.com and click on Ask a Lawyer.